Yeah, that's very good. I want to congratulate you all, not only for showing up on time, but for choosing the best workshop on this floor. It has a wonderful, distinguished panel here, and we pledge to make sure that you get answers for all your questions. And if we don't have the answers, we'll just make them up. But we'll make sure that you leave this room with the right answers. It's a great privilege and honor for me to be acting as the moderator of the debate of this distinguished panel. As you have seen, we have a wonderful title, The Legal Framework of International Trade, What Experts Need to Know. And please do not understand from that title that non-experts are not welcome here. In fact, it is especially for non-experts that this panel is made. First, we believe that in every person who believes that she is a non-expert, there is actually an expert waiting to be unleashed, and one of the purposes of our discussion will be to unleash that potential. And it is also something that I feel very strongly about. I don't think that trade and law should be kept only to the experts. At the end of the day, law is here to support trade, to ensure that legal certainty is achieved throughout trade, and this is something that should bring experts and non-experts to interact together. I guess my job will be pretty easy today. The job of a moderator is actually twofold. First, make sure that a coffee break is timely called, and I will make sure that we have the coffee break at the right time. And second, to ensure that his colleague speakers stick to their time. And this reminds me also of the story, and I'm sure that you know the story of the gentleman who showed up at a municipality because he had a formality to be done. And the municipal officer told him, well, you need to sign at the bottom of the page. And the gentleman said, well, actually, I am illiterate. I don't know how to sign. And the officer said, well, that's easy. All you need to do is simply to put a cross at the bottom of the page. And the gentleman took the pen and in a very applied way drew a first cross and then a second cross. And the municipal officer said, well, why two crosses? And the gentleman replied, the first cross is actually chairman. So you can see that it does not require a lot to chair a panel of this type. It is important throughout this morning that we would have an open dialogue, a free exchange between us. That's how you make it interesting for the speakers and for yourself. So please be generous with your questions. Feel free either to interrupt a speech with a question that would allow us to get focus on what really is of importance to you, or to save your questions to after the presentation. We will be breaking at some point, according to your desire or to the desire of the speakers, to enjoy some coffee and some of the record discussions. And with that, I would like to introduce my colleague panelist. I will start on my left with David Corris, who is the chairman of the International Chamber of Commerce Intellectual Property Commission. And when he's not doing that, he is the general counsel and the head of intellectual property for Shell International BV in the Netherlands. Professor Jan Ramberg, very well known gentleman, emeritus professor in private law and former dean of the law faculty of the University of Stockholm. I've known Jan for a long, long time, and I am no longer allowed to call him the father of Incoterms, because he argued yesterday in a compelling way that if you call me the father of Incoterms, that means that I was at least 18 when the first version of Incoterms was drafted, which makes my age now somewhere between 100 and 105 years old, which of course we know this is not the case, so I will call him as the world foremost expert in Incoterms, and it's a great privilege to have you with us today, Jan. Professor Jim Byrne, sitting on the right of Professor Ramberg, is the director of the Institute of International Banking Law and Practice and a distinguished member of the ICC Banking Commission. It's great to have you here, Jim, with us. David Goldberg is sitting very modestly there. He is a very well-known specialist in international arbitration and international dispute resolution with wide experience in arbitration with CIS and Russia. Alexander Muranov will be joining us at some point. So he is with us in spirit, and I'm sure that he will be joining us. I think he's sitting on another panel and will be coming here soon. He is the managing partner of Muranov, Chernyakov and Partners, and professor at the Moscow State Institute of International Relationships. Last but not least, Vladimir Valey. He is the Vice President of the ICC International Court of Arbitration and partner of Baker McKenzie in Russia. Now, Vladimir has indicated that because of an important case that he is arguing, he will have to leave us in around 30 minutes. But thank you very much for making the effort to join us today. Now, because of that, I will defer my introductory remarks about rulemaking in international trade until after Mr. Valey has delivered his remarks. His remarks will be centered on the first part of his duet with Mr. Goldberg, and that's Lex Mercatoria in ICC International Court of Arbitration practice. Vladimir, you have the floor.
Thank you very much. Can I have my slides? Извините, можно мою презентацию показать? Because I understand our audience is fluent in English, I'll probably stick to English, although I've got my presentations in Russian. So we'll have a benefit of having both languages here. What I would like to talk about, international lex mercatoria or trade usages in practice of international ICC, International Court of Arbitration. And before I start my presentation, I would like to make definition what is trade usages. And I would like to use definition from Article 5 of a Russian Civil Code, which actually defines trade usages. And it says that the trade usages is well, I need to translate it from desk. Established and broadly applied in some area of business activity, rule of conduct, which is not directly provided by the law, irrespective of whether it is formalized by some document. So basically, what Russian Civil Code says is that trade usage is rule of conduct, which is used in a business community, and it does not really matter whether it's formalized by the law or not, which is very important because very often the question is where could I find trade usages? And Russian Civil Code says, and international practice also goes in this line, that even if it's not fixed or formalized in documents, not necessarily the law, it's still trade usage. What are the most popular or frequently quoted provisions or documents of Lex Mercatoria? Of course, mainly what comes into mind is UNIDROIT principles of commercial contracts. Then, of course, one could say about Incoterms as broadly used in international trade. Of course, we are talking about numerous ICC documents like ICC demand guarantees rules or letter of credits and all other ICC publications, which in essence indeed trade usages because these documents were prepared and drafted on the basis of summarizing business practice in different countries around the world and published by ICC, and by publishing they become trade usages. Sometimes also arbitrators are quoting principles of European contract law, although this is not law in a sense, but very often they are referred as describing general principles of law common to all European community. I also would like to quote one ICC award. There are several quotes in my presentation where the tribunal in one of the cases stated that UNIDROIT principles are a reliable source of international trade law in international arbitration because they incorporate the fundamental principles which have universal recognition. And I think it's also a pretty fair definition of Lex Mercatoria. I also would like to draw your attention to one of the ICC awards where the tribunal tried to summarize what are the main principles of international trade law. And the tribunal listed 8 principles, started with pacta sunt servanda, good faith, obligation to have negotiations in good faith, termination of the contract in case of substantial breach by one of the parties, and interpretation of the contracts and some other principles. I don't want to list all of them now. What are the legal basis? What is the legal basis for applying lex mercatoria? Because this is a question which is very oftenly asked by parties or by the tribunal. And I divided legal grounds in three parts. First of all, agreement of the parties. Secondly, provisions of applicable law, and procedural rules. I'll start with agreement of the parties, and I would like to refer to Russian law on international commercial arbitration, which reiterates UNCITRAL model law international commercial arbitration. And Russian law says that tribunal resolve disputes in accordance with rules of law which stороны choose as applicable to the merit of the dispute. And specifically, I want to mention that this law refers to rules of law and not law, because usually reference to law means national system of law. And when we're talking about rules of law, we are talking about any rules of law, and lex mercatoria also are qualified as rules of law. Also, ICC rules are saying that the parties are free to choose any rules of law which should be applied by the tribunal to the merit of the dispute. So ICC rules also refer to rules of law and not law. What is the benefit of lex mercatoria for the parties? First of all, lex mercatoria is easily available to all of the parties in equal sense, because when one of the parties insists on the national system of law, this system of law might not be available for the other party. Lex mercatoria is neutral for all the parties, and lex mercatoria takes into account usages and traditions of international trade. Apart from agreement of the parties, even in the absence of agreement of the parties, lex mercatoria still could be applied by the tribunal, and legal ground for it could be found in Russian law, because Russian constitution, Russian civil code says that generally recognized principles and provisions of international law and international agreement of the Russian Federation is part of its legal system. So Russian constitution refers to international principles of international law, generally recognized principle of international law, and lex mercatoria for sure is recognized principle of international law. Also, Russian law on international arbitration says that in all cases the tribunal should take decision in accordance with the contract terms and trade usages applicable to this transaction, which also gives additional ground for the tribunal to apply international trade law. And also, indirectly, this notion is supported by the idea that any mistakes in applying rules of law is not ground for setting aside the award or refusing to enforce it, which gives a tribunal a pretty broad discretion in using lex mercatoria as well. There was some discussion in Russia with regard to Article 28 of Law on International Commercial Arbitration, which says that in absence of agreement of the parties, the tribunal should apply a law which is to be defined in accordance with conflict of law rules, which the tribunal finds applicable. And some people are saying that this provision obliges the tribunal to apply law, but not rules of law. However, I still believe that there are some other provisions which allows the tribunal to apply trade usages. I quoted one before, that in all cases the tribunal should take into account trade usages. And also, the ICC rules are saying about rules of law and not law, which one could construe that party by agreeing to apply ICC rules also agrees the tribunal could apply rules of law and not law. I also would like to quote a couple of court decisions in different countries where the state court stated that the arbitrators are allowed to apply lex mercatoria in case when the parties did not make choice with regard to applicable law. It was stated by Cour de Cassation in Paris in 1989. Similar decision was taken by Austrian Supreme Court in 1982 and English Court of Appeal in 1987. Additional arguments in applying Lex Mercatoria is that these, again quoting the ICC award, that Lex Mercatoria apply unique method and they are independent of peculiarities of particular legal system. However, there are also difficulties in applying Lex Mercatoria because Lex Mercatoria is not civil code in a sense and it does not cover all possible civil law relations. So some of the issues are not regulated, but Lex Mercatoria and tribunal still needs to apply national law. Also, there is no uniform practice of application of international trade law in comparison, for example, with English court decisions, which are pretty well structured in a sense and cover all possible issues. And also, I'd like to mention that in absence of agreement of the parties, arbitral awards based on Lex Mercatoria only might not be recognized by some state courts. In particular, for example, the Republic of Belarus, where recently Supreme Commercial Court stated that Lex Mercatoria is applicable on unilateral principles only when party is directly referred into the agreement. Now, summarizing ICC court practice, I could tell you the following. First, according to ICC statistics, unfortunately, it's not very often when the parties are directly referred in the agreement to Lex Mercatoria as principles, as rules of law to be applied in their contract. A number of cases each year does not exceed 10 out of whatever 800 cases submitted to ICC court. Tribunals more often apply rules of Lex Mercatoria, however, do it very carefully. So usually they avoid situation when they rely only on Lex Mercatoria. Rather, they do it in combination with applicable national law. So they rely on provisions of national law, they rely on UNIDROIT principles saying that, well, in this situation, in this case, applicable law is not different than internationally recognized principles of trade law. But the growing tendency is that the tribunal more and more often rely on international trade law, and I think that in future this tendency will also continue. That's all I've got to say. Thank you very much for your attention.
Thank you very much, Vladimir. I have a lot of questions for Vladimir, but I'd like to defer to you first, if you would like to take advantage of his presence. Vladimir indicated graciously that for the next 10 minutes he is available to answer your questions for free, and this will change the minute he steps out of this conference room. So I would suggest that you take advantage of that. Please, can you please introduce yourself, your organization, and then put your question to...
My name is Anton Asoskov. I represent Lomonosov Moscow State University. Vladimir, can you please elaborate in more detail about this Belarusian decision? So in this case, Belarusian courts decided not to recognize and enforce the foreign arbitral award because some principles of Lex Mercatoria were applied?
Usually when you have a strange decision, unusual decision of local courts, usually there is some story behind it. It's not because local courts are against Lex Mercatoria, but there's an important case against important national company, and then, state courts are trying to find a way to protect it. And in Belarus, it was not exception. There was a decision against one of the Belarusian companies or even bank, and this decision relied in calculating interest on UNIDROIT principles. And because Russian company did not want to follow this award, they were trying to find a way how to not pay under the award. And they invented this ground that UNIDROIT principles should not be were applied wrongly by the tribunal because they were not referred directly by the parties. And Supreme Commercial Court unfortunately supported this position and said that UNIDROIT principles are applicable only when parties directly referred to into the contract. And this is, well, obviously it's not the right decision, but it's decision, and one should take it into account when taking decision or award against Belarusian companies. Or at least there should be in a draft award good reasoning to the effect that when, for example, tribunal applies under ICC rules trade usages, i.e. UNIDROIT principles, the tribunal should refer to agreement of the parties stipulating ICC rules, and ICC rules provides authority to the tribunal to do it. So there should be some justification, but still, I think Belarus is not exception. I mean, in many countries, state courts are very careful in applying, by their own motion, if you want, principles of international trade law for many reasons. So this is why, as I said, tribunals usually take very conservative approach, although the tendency is positive. But I understand that David is going to criticize the system, but it will be later.
And in this case, the Belarusian courts applied which ground from Article 5 of the New York Convention?
Well, I frankly don't know. I don't know the details. I just recently heard about this case in Belarus, but it was, I think that it was a decision of Supreme Commercial Court summarizing practice of resolving disputes, or it could be, or probably I was wrong. It was not arbitral award, it was decision of state court. And when supervising decision of state court, they reversed the judgment saying that UNIDROIT principle should be applied only when it was directly provided by the contract. So it was not arbitral award. Yeah, I just recollected.
Thank you.
Other questions? Well, I have a question for Mr. Kvade. Mr. Kvade, in the 80s, when the idea of a non-national body of law started to emerge, the big challenge was, are we talking about a system of law that is there a legal character to the general principles of law, to the trade customs and usage, and of course the fact that we gave it a Latin appellation, lex mercatoria, was supposed to add weight to it, even if it does not have anything to do with the medieval law. But I believe that thanks to a number of visionary judges sitting in various courts in the world, and you were gracious enough to refer to the leading role that the French Supreme Court has played in this respect, right since the mid-80s, end of 80s, we established beyond any doubt that where the parties refer in an international contract to a non-national body of law, such as the general principles of law, international customs and usage, we are talking about the legal system. So you don't risk the cancellation of your contract for banning any law. But then the question that we're left with, and that is still debated until today, is assuming we agree that the party's choice of lex mercatoria is enforceable, and I would like to ask you to take that as a given point. Where do we find lex mercatoria? To which law library would I go, and what book should I pick up from the shelf and open it to find the answer to that? And the question is still debated today. And I'd like to ask you perhaps to address that point. You are a well-known practitioner of arbitration and court litigation, but also you sit frequently as arbitrator. Where should we find lex mercatoria? And Dion, I will ask you to take the floor afterwards to give us your advice as well.
Well, let me start from the very beginning that principle Jurit Nova Curia has very limited application in international arbitration. I principle that the judge should know the law, or the judge knows the law and should investigate issues of law. Issues of law are subject to proof in international arbitration. So if one of the parties relies on international trade law, lex mercatoria, this party is to prove that there is indeed provision or trade usage which is to be applicable in this particular case, and the circumstances of this case justify application of these principles. How it is done in practice and what parties usually have in mind or what parties usually refer, I think that one Incoterms obvious example, even if Incoterms is not directly referred by the parties, but you see the term FOB St. Petersburg, for example, usually there is no doubt that the parties imply to have Incoterms, and where you could find Incoterms, it's easy way. In banking area, I think it's also no-brainer, because if one of the if a bank issues demand guarantee and doesn't specify that this demand guarantee is subject to, for example, ICC publication, and there is some unresolved questions, then the tribunal or party should understand where to find provision to be applicable to this unresolved question. And of course, if they rely to ICC publication, if it's not directly referred by bank guarantee, I think it's a good reference to international trade law. And of course, UNIDROIT principles. UNIDROIT principles are more and more often quoted by parties in international arbitration, and tribunal do pay attention to it. Of course, when we are talking about non-written trade usages, well, it's a pretty difficult issue because usually how you prove that this is a trade usage in particular area, or for example in particular port, then of course you need to have experts. Somebody like you who could say, well, I have been practicing for 30 years, whatever, in this area, and I could tell you that it was always the case that it's done in such and such manner.
Thank you. Jan, could you add remarks?
No, I use this one here. Yes, the entry into Lex Mercatoria, I think you should observe Article 9 of the 1980 UN Convention on International Sale of Goods, because it says that you could expressly refer to a trade usage. Then it is a term of the contract. The difficulty starts when there is nothing in the contract. Then the article goes on to say that you could imply a trade usage. And then the next question is, when do I dare to imply something which is not in the contract? And then the notion is, if it is widely known and regularly observed in the trade which we are concerned with. And now if you apply that one, that notion, I think that Incoterms undoubtedly would qualify as widely known and regularly observed, but I will come to that later. And I would say that Incoterms as a whole would not qualify as Lex Mercatoria and trade usage, not as a whole. But if you take one of the old terms, such as FOB or CIF, which have been used through the centuries, they would constitute Lex Mercatoria and a trade usage. I'll come to the other ones later, where they are more like a standard contract. And it's a mix between Lex Mercatoria, trade usage, and a standard contract, which requires reference in order to come into the contract.
This is just my follow-up question. This is because new Incoterms introduced new terms which were not in usage before. So therefore, you cannot say that it was widely recognized and commonly used. Yeah, this is your logic. Yeah, I agree.
I wonder if any one of the other panelists would like to add his views. Jim, David. I guess the point that I was driving at is to remind everyone that Lex Mercatoria is more a method of identifying on a case basis the appropriate rule or usage. Do not ever hope to find a compendium, a collection of all Lex Mercatoria rules. Not only because it's impossible to exist, but because that would be doomsday, it would be the end of Lex Mercatoria. I think that the fact that it is not exhaustively codified is really what makes Lex Mercatoria so attractive. It will always develop to adapt itself to the requirements of commercial transactions as they exist at the time when you are looking for that rule. So please consider that as a method rather than as an exhaustive compendium. Thank you so much, Vladimir, for... Of course, please feel free to give. Which brings us now to resume the normal framework, and I was supposed to start with those remarks. The organizers assigned to me the topic of the rule-making activity in international trade. And I thought I would take as example the activity of the International Chamber of Commerce, which is well known for over a century in its rule-making practice. Let me start with a remark. I think that it's a given, and the expert audience will, I am sure, agree that today the move towards globalization in the economy is irreversible. Everything is today global. You go to a St. Petersburg restaurant, you order wine, and you find on your list French wine, which has been delivered through UPS an American company that has used its logistics platform in Dublin to get that wine present. I think it's also a given that trade today is really the most important factor in growth. You will all remember the concern that was voiced by the Director General of the WTO, Pascal Lamy, not when the financial crisis erupted, not when Lehman Brothers collapsed, but when the financial crisis resulted in the decrease of trade volumes, because at that stage we reached a level where world growth really became in jeopardy. And I'd like to suggest to you that the linchpin, the most important part in trade, is leveling the playing field by having a common framework of legal rules. Excuse me, I think that this door should remain closed, please, just to avoid distraction. Thank you so much. I apologize for that. So it's very important to allow businesses and the legal advisors a common legal framework where the same rules of law, or as close as possible in their concept, in their drafting, would really allow the business people from all over the world to deal on a level playing field. There are obvious advantages to having common rules of law to govern international trade. And can I ask you what you think would be the advantage of having a French exporter dealing with a Russian importer, and in between an English bank with the same legal framework? What do you think could be the obvious advantage? Just give me your thoughts. Usually when I ask the question to my students at the university, I have about 25 hands immediately rising up. Okay, in that case, let me ask Professor Ramberg. He's always my favorite target. What do you think would be an obvious advantage of having common rules governing international trade, Professor?
Well, I think my answer is to that, that you save money, you reduce transaction costs. Now, if you have an arbitration, for instance, and you have to pick the applicable law, and that happens to be the law of one of the contracting parties, the other contracting party would have to engage a lawyer to assist, because there are different laws which could have been picked, and therefore you have to have a legal opinion by me, for instance, on Swedish law, and I charge for it, very cheap, but anyway. So the answer is very simple. If you have common principles, such as UNIDROIT principles, you save money, because you don't need all this extra costs for legal opinions and so forth about a particular national law. You take the important legislation which I mentioned, the UN Convention on Contracts for International Sale of Goods. Just imagine if you didn't have it, and you were to apply, I think there are about 73 states all over the world that have ratified that. It represents world law, whether the UK likes it or not, because they have not ratified. It's world law. And just imagine the saving of money by reducing the transaction costs when that convention applies. That's my answer.
Thank you, Jan. Now, David, you and I are both in-house counsel in global companies. What difference in our day-to-day life would having a common framework of legal rules governing our cross-border deals make?
Well, first I'd just like to address the comment made by my distinguished colleague. Now, I'm sure we are all agreed that, that there is no profession that is more deserving to get the additional funds than the lawyers. I think so. So right off the bat, I think that we need to get that point across. But from a business perspective, when you engage in global planning of selling wines on an international and then international basis, it is all about risk mitigation, and risk mitigation translates into economics. So I think one, it provides the confidence for longer range planning. You might be willing to select a different assortment of wines, and certainly the relationships you build with distributors, it affects all the way down the line in terms of the risk you feel involved in the individual contracts, the enforcement mechanisms. In essence, it's a means of leveling the playing field.
I agree with that. And obviously, there are many more advantages. Think of all those countries which are transiting into market economy and which do not have necessarily the most up-to-date legal system. By adhering to an international treaty governing one or the other aspect of international trade, they will be able to bridge the gap in their systems. And guess what? When they end up with a world-class legal system, then foreign direct investment will also feel more confident to come and invest in their country. You will remember that one of the most brilliant moves done when a number of Eastern European countries moved into You will remember that one of the most important moves in accompanying a number of Eastern European countries in their transition to the new economy was the offer by the EBRD, the European Bank for Reconstruction and Development, of a model secure transaction law that allowed over 20 countries to get themselves a world-class security interest system based on registration, which enhanced credit, brought down the price of that credit, and therefore furthered growth. It is also arguably one of the most efficient means to enhance the prospect of a common market. In Europe, when we decided to move into the single market, we started by harmonizing our rules of law for the various segments of the market. Now, if we were to accept the idea, therefore, that it can only further international trade to have common legal rules, we need to ask ourselves then the question, how do we do it? And who should do it? And I'd like to prolong my remarks for 5 more minutes by illustrating them with my experience, which ended only recently, in drafting rules for demand guarantees under the aegis of the International Chamber of Commerce. The Uniform Rules for Demand Guarantees were adopted, ladies and gentlemen, unanimously by the ICC 2 years ago after participation by over 60 countries from all over the world, which have contributed over 600 sets of comments. It was a daunting exercise, but I'm extremely proud that thousands of men and women all over the world today have a common framework of reference that levels the playing field when they have to deal with guarantees. The first question that we had to address before embarking in such an important project was, is there a need for harmonization? The last thing that you want is answers looking for questions, solutions looking for problems. So you need first to poll the sector where you're planning to offer your rules. Identify exactly the topic that needs harmonization, and then decide to move towards that harmonization. We achieved that at the ICC by launching a questionnaire to which thousands of banks, businesses, but also regulators from all over the world have participated, indicating that the existing rules for demand guarantees were fine, but were starting to get old. So they needed some rejuvenation, and it was time for us to start into our modernization work. And you need then to test the market to see what exactly should be the answer. You are aware, I am sure, that there are a number of international organizations which are active in the area of offering harmonized rules for international trade. Some of them are international government organizations. An example would be one or the other of the United Nations agencies, for example, UNCITRAL, the UN Commission on International Trade Law. Because it is a governmental organization, UNCITRAL, like UNIDROIT that was mentioned by Vladimir a minute ago, can offer law-like rules. They can have treaties adopted. Treaties have to be ratified by governments. And if they are ratified, they become with the same authority as the law in that country. Another way for those governmental organizations to also harmonize the rules of law is to have a model law. Now, a model law does not have to be ratified, but it is a model for the local lawmakers to have their own national laws drafted according to that model. Contrast that with a non-governmental organization like the International Chamber of Commerce. Now, I'm sure that you're familiar with the ICC, but let me remind you that it's an organization that was created around 100 years ago by visionary men and women from both sides of the Atlantic that were called the Merchants of Peace. We were immediately in the wake of the First World War, and those men and women decided that there should be no longer wars in the world because nations should trade together. We have empirical evidence that nations which trade with each other do not go in war against each other. And since then, it has been a wonderful success story of the ICC. Many of its rules are well known to you. We've heard about the Incoterms. You've heard about the uniform rules for demand guarantees. I'm sure you're familiar with the uniform customs and practice for documentary credits, etc., etc. Now, ICC is a non-governmental organization, which means that it cannot draft laws. It can draft contractual rules that would apply if you, the lawyers, the businesses, were to incorporate them in your contract. It's very easy. My guarantee is subject to the uniform rules for demand guarantees. My documentary credit is subject to UCP. The Incoterms are part of my international sale agreement. So according to the level of harmonization and the authority of that framework of rules, you will choose the organization that should embark on the project. When you deal with ICC rules, you need to know that because we're talking about contractual rules, they will apply only if you decide that they should apply as part of your contract. There are areas of law which are considered as mandatory, and contracts cannot go there. This is the reason why the UCP, Incoterms, and the URDG cannot go into areas like capacity, corporate empowerment, fraud, court injunctions. Conversely, they can regulate every aspect of the transaction that is open to us as parties to the contract to build into our contract. You need also to have an organization which is offering its support to the new rules, which is sufficiently representative of the main political, economic, social, cultural, and legal systems of the world. You don't want to have rules which are drafted under the rules and the framework of one country or even one region and then purporting to apply all over the world. This will never happen. It will never be a success. It will just go into your shelf as one more example of unapplied, unused rules. The ICC, by contrast, is the most representative organization in business. It is present in over 95 countries, and it is formidably active in rule setting. It is important also that when you start your drafting of the rules, that you don't succumb to the temptation of closing the door and working obviously diligently and hardly with the other members of the drafting group and then emerge 2 years, 5 years down the line with the new rules. You need to keep constant contact with the sector that you're planning to offer the rules to. Throughout my codification work of the rules for demand guarantees, we had 5 world consultations. We issued 5 drafts that were circulated throughout the world, and this has prompted, as I indicated, 600 sets of comments, series of comments from all over the world. And that helped us to identify areas that were completely wrong and areas that we forgot, but also offered us the satisfaction of knowing that some of our rules were absolutely right. This is, in short, my experience in drafting rules for the ICC. I wanted to share that with you as an illustration of how the ICC, the World Business Organization, offers rules for international trade that, at the end of the day, depend in their application on your desire. You, the council, or the parties to a commercial transaction. Do you have any question on my presentation so far? You will have other opportunities. I'm staying here until the end of the presentation, so you don't need to worry. And with that, I'd like to turn over the floor to Professor Ramberg to deliver his remarks on Incoterms, the universal language for global trade. Jan, you have the floor.
Yes, now you can look at the screen, which will give you a picture of the history. I would say this, that George pointed at the way in which the ICC works. Now, there is a little bit of a difference between demand guarantees and Incoterms, because the old trade terms were essential, because otherwise you cannot implement your bargain. And in the old days, in the 1700s already, there was a ship, and it was for the buyer to contract for the ship, arrive in a foreign port, and there the seller would lift the goods sold on board the ship. So you got free on board. Free to the buyer, the goods should be on board the ship. Now, the expression FOB is, of course, not enough to understand exactly what the parties are supposed to do. And the trade terms, they are the tools for the parties to implement their bargain. And you must know much more than to put the stuff on board. You must know what documents should be provided by the seller, so that the buyer would know that the goods are on their way. As a buyer wouldn't like to pay, would he, before he knew that the goods had actually been placed on board. There must be a document there. And the document then is combined with the ICC rules for documentary credits, which would require a document which would go to the bank with a document and you get paid. So these rules, different rules, they work in conjunction. Now, already in the 1920s, well before I was born, by the way, then studies were made, very serious studies by the International Chamber of Commerce, and it was then found that merchants understood these trade terms differently. Now you take a more complicated term like CIF. That is means that you have several contracts. You have the basic contract of sale, you have the contract of carriage, and you have the contract of insurance. And all these must be combined. And of course, that is not an easy task to do. And therefore, people understood this differently. And something had to be done about that. And then it all started then with the first version of Incoterms in 1936. And there, of course, at that time, what did you have? Commodity trade, oil, timber products, and grain, and stuff like that. And these commodities were carried by ships. You did not have very much of manufactured goods at that time. And keep that in mind for a moment. So quite naturally, you did focus on terms related to the ship. FOB, of course, CFR, which is then only carriage, and then CIF, where you have an obligation of the seller to insure the goods with the buyer as beneficiary of that insurance cover. Now, after the war, the Second World War, then, because during the war everything came to a standstill, but then immediately after the war, now the railways had picked up a little bit, so you had to have trade terms also for carriage of goods by rail, and therefore you got the additions FOR and FOT in 1953. And then you had further on the sellers. They dared to sell the goods delivered at destination. Just imagine, they had to arrange everything for the goods to actually arrive at destination. So they had to make a contract of carriage for their own in order to fulfill the obligation to bring the goods all the way up to destination. And then you had these additions. They all start with the letter D for destination. And there were variants of that. If you have a ship, the question arises, well, the ship is there, the goods are in the ship, but who of the seller and buyer should be responsible for picking out the goods of the ship? And then you have delivered X ship, DES, where it is for the buyer to discharge the ship and get the goods into the country of destination. And then you have delivered XK. That is when it is for the seller to ensure that the goods are actually landed in the country of destination on the quay. And then you had something very important, but now, of course, it had to do with the railways again, mostly. You could deliver at frontier, the frontier of the country of destination, no further. But there you were, and that is the railway. And then the buyer will be responsible to bring the stuff into the country of destination. Now let's see if this one works. Here we go. Yeah, at the outset, when you had commodity trading, you had the maritime terms, I would suggest that at that time it was merely the job was to get the rules into Incoterms representing trade usage. And there was nothing more. However, there was a policy change in the 60s. Why? Well, because of the method of carrying the goods. Containers came into the picture. So the goods were actually stowed into containers before the arrival of the ship. And the question then arose, where is the point at which the seller has fulfilled his obligation? And you could then see in the 60s how different trade terms popped up. And there was a proliferation of different variants. And of course, that was to the International Chamber of Commerce a nightmare. What should you do? That would really be to do nothing, to risk the very benefit of Incoterms. So the policy changed in that the ICC did not merely reflect what was going on in practice. They had to be innovative and invented a new trade term, which is now dominant for the carriage of manufactured goods, as distinguished from commodity trading, and that is free carrier named point, FCA. Now the relevant point is the delivery of the goods into the charge of the carrier, irrespective of the method of receiving the cargo, at a terminal or perhaps even at the place where the seller finds himself, at the seller's place. It could be any place, but you should name it. Seller's premises or an indicated terminal in the seaport or whatever. Name the point. If you don't name it, you're in trouble. But then you have to interpret the contract in any way. It is the point at which the carrier takes the goods into his charge. Now, as it happened, the forerunner to this FCA was actually a very peculiar expression, FOB airport. But How is that possible? There is no ship in the airport free on board. Aircraft, not ship, FOB airport. How could you do such a thing? Well, you could because of the Americans, because they used FOB as meaning free. FOB Las Vegas is quite possible in the United States. You don't have to have a ship. There are no ships in Las Vegas, in the desert, but you can still use that. So the Americans were enthusiastic about this sort of thing, FOB airport. It should prove to be rather short-lived. The term does not exist anymore in Incoterms. But it was a forerunner to free carrier named point. Of course, with free carrier named point, it could be any type of carrier. It could be a road carrier, rail carrier, air carrier, or maritime carrier. Now, so therefore these disappeared in 1990 version of Incoterms. And then you had something also again, because you had changed the focus on the ship, and therefore you needed a CIF for these other modes of transport when there was no ship, and that became CIP, signifying the point up to which you were to insure the goods. Now, let's try again. The next one. Okay, that's called group 1. You point there, okay. All right. Now, there's another important thing, and that was the 1990 revision of Incoterms. And then the technology had changed insofar that you could actually prove that you had fulfilled your obligation not by having a paper document, but you could have an electronic equivalent to paper. And that came into Incoterms 1990. And you could even replace such an important document as the Bill of Lading, which is a fantastic document because by the transfer of the Bill of Lading, you could actually transfer the rights in the goods. And that could also be done by electronic communication, the EDI, electronic data interchange. Now, it's an important point. I know particularly in Russia, it's very important with customs. And you have to know absolutely for sure who is responsible for bringing the stuff through customs into the country of destination. And there you had, in the old days, you had the customs border was actually the ship's side. As long as the goods were stuck in the ship, they had not yet arrived into the country. And therefore, you had a distinction between free alongside ship and delivered ex quay. And of course, at destination, you had delivered ex quay. You had to jump over the ship's rail and onto the quay. Now the goods had to be passed through customs by the seller. If you have free alongside ship, the goods were not yet above the ship's rail, and therefore they had not yet left the country, and the obligation to clear the goods through customs fell on the seller. Now, all that changed, of course. The customs procedures changed, so therefore the ship's rail is gone in that respect. And therefore you have to clarify in each individual term who is responsible to pass the goods through customs. Now, in the 2010 revision, which is now leading to Incoterms 2010, you will find another innovation. It's basically how you present the terms to the users. And it was found that in many cases, the parties simply picked the wrong term. They continued to pick FOB when they ought to have picked FCA. And therefore, and it started already with an important document by the ICC, and that was the International Sales Form, the standard form presented by the ICC for the sale of manufactured goods, as distinguished from commodities. Now there you can find the recommended terms for manufactured goods, and then you find other terms which were really not recommended, and those were the maritime terms. Now this is reflected in the present version of Incoterms in Group 1 and Group 2. Group 1, you start with manufactured goods, and there you find appropriate terms, the same as you find in the International Sale Form. And in Group 2, what do you find there? The old terms from 1700s and onwards, FOB, CIF, CFR, would be in Group 2. Now, there is another innovation in Incoterms 2010. You find new terms, DAT and DIP. And why? Well, again, it has changed. Manufactured goods could be delivered not in the seaport, but anywhere. They could be delivered at a particular point, which could be anywhere. And in particular in the United States, where you used FOB signifying only a point, which could be anywhere, in Las Vegas, not in the seaport. The term delivered at point, DAP, was introduced into Incoterms. But don't forget to mention the point. Then you have a frequent case where the goods are delivered at a terminal from which they are to be picked up by the buyer. So that term is also new and was introduced 2010, delivered at terminal. Now then, that signified that you could scrap the old terms delivered at frontier. Well, if you wish to have the frontier, name the point. You could scrap delivered ex-ship and delivered ex-key. I sort of thought that, well, isn't that a pity? They have been there for such a long time, ex-ship and ex-key. Well, we'll take the youngsters, in the revision process, we'll take care of that, it's no problem. We have a terminal, delivered at terminal, and we simply make a definition of terminal, which would include the key, and therefore we don't need that anymore. So these two terms were scrapped, and delivered ex-ship, yeah, ex-ship, name the point. If you like it, you say the point is ex-ship, delivered at point. So therefore, these two old terms were believed to be no longer necessary, but they will still be used. So you have a problem if parties refer to Incoterms 2010 and pick the old terms which are in the version of 2000. What do you do then? Then you have to interpret. You say the parties must have meant DAT or DAP, respectively. Now, there's one thing which I don't like. I'm very loyal to the ICC, of course, having served for so many years, but I think the trademarking of Incoterms, I don't like that. And I can explain it to you. And it has to do with the important cooperation between the governmental organization UNCITRAL and the non-governmental organization ICC. How come that the definition of trade terms were not included in the UN 1980 Convention on Contracts for International Sale of Goods? Why were they not included? UNCITRAL thought that the ICC is far better to follow up. You can't have amendments of a convention as technology changes. That is for the ICC, through the national committees all over the world, to ensure that the trade terms are understood and up to standard at every given moment in the future. Instead, UNCITRAL decided to endorse Incoterms. That's a cooperation. But how could you trademark such a thing? You could trademark the name, but you cannot trademark the product, because that is equivalent to law. That is lex mercatoria. But you see, these very fine distinctions are not always understood by everyone. Now, let's see if we can get another one. And then I'll finish. Don't worry. Well, here we are. Let's see. Yeah. That's merely to reflect what I said about the group 1, simply so you can see that these terms, ex-works, free carrier, and so forth, all the way up to delivered duty paid, they may be chosen for maritime transport, but they should be chosen for wholly or partly non-maritime transport. Remember that. May be chosen, should be chosen. And the next one. Yeah. And this is group 2, maritime terms. And you find the old terms, free alongside, free on board, CFR, CIF. Should only be chosen for maritime transport and not for non-maritime transport. Don't forget that. And then the final one. Well, again, I think that the choice, I will leave this to you for questions to save time, but this reflects how you choose between the terms. And I think I leave that for questions. You could take the other one. Yeah. And yet, the group 2. And you see the choice within group 2. And to finish, I will give you the ICC Incoterms wall chart, where you can see how the obligation of the seller proceeds towards the buyer from his place up to the buyer's place. And I will also add that it's difficult to read perhaps by distance, but there is the wall chart. You can see the red line then proceeding all the way up to the red line is from buyer to seller. So the buyer, which is on the right-hand corner, would have to assume the risks for the whole carriage. Well, there it is. Well, beautiful, isn't it? But anyway, it gives you a quick picture of what the trade terms are all about. So I think that Incoterms are there to stay.
Thank you so much, Jan. Three remarks, ladies and gentlemen. First, I think that the world owes a huge debt of gratitude to Jan Ramberg for having shepherded a number of successive revisions of Incoterms. You deserve the title of the father of Incoterms, whether you like it or not. And I think that this room also owes you a debt of gratitude for this wonderful overview of the Incoterms. The second remark is I thought that you nailed it right on the head when you emphasized on the lack of cooperation between international governmental organizations and international non-governmental organizations. You gave Incoterms as example. I'd like to give the counterexample in the area of demand guarantees. When UNCITRAL was working on their convention on independent guarantees and standby letters of credit, we at the ICC made sure that they refer to the uniform rules for demand guarantees in their official commentary to the convention as the perfect example of those customs. It was not as good as if we had joined hands in having one common text, but it was the second best solution. And the third and last remark before opening the floor for discussion is Svetlana and Alexandra will be happy to show you examples of various ICC publications about the rules that all the speakers are referring to, including Incoterms, the UCP, and Uniform Rules for Demand Guarantees. Now, the floor is yours, and you're welcome to put questions. Madam, your name and organization first, and then your question.
My name is Anna Akipova, and I'm here on behalf of the Research Center of Private Law. But the question actually comes from my previous private practice. I came across several times situations where the parties were referring in their contract to one Incoterms basis, but their actual relations were quite different. So, for example, the parties stated that the contract was based on CIF terms, but what they did in reality was DDU. So the seller was actually doing everything, the customs and so forth. So in Russian practice, particularly court practice, the approach would be to incline, at least in favor of the written evidence, because Russian procedure is based on more written evidence than any other evidence. So what I would like to ask, Professor Ramberg, if I may, what is, based on the spirit of Incoterms, what would be the right approach? How do you think? Is it the approach of the written document, whatever the basis is stated in the contract, or is it the actual intent of the parties, which I think in such situations can be quite clearly seen? Thank you very much.
Well, here again, needless to say, the parties are strongly advised to refer to Incoterms explicitly. And as I said, that is not enough. They also have to indicate the point, because otherwise you have problems. Now, lawyers, and arbitrators, they are aware of these problems, that contracting parties, they don't do what they ought to do. So therefore you have to work with this situation and do the best you can. Now, I mentioned to George, I think this morning, about a case where you had a flat reference to FOB. It was a huge contract. It was a dangerous contract because it was for the export of nuclear waste into a very delicate union. I will not say more because it was a big arbitration, one of the biggest ever. Now, FOB, all of a sudden, it was disliked internationally that this export should take place at all. So there was immediate legislation prohibiting export of nuclear waste. FOB, key question, who was responsible for the export of the goods, seller or buyer? You see? And there was a legal opinion written. I will not disclose who wrote it, but anyway, you had a flat reference to FOB under national law, and you had Incoterms. Would Incoterms that explicitly provides that the export obligation is on the buyer? The buyer was in a trap and could face and did face an enormous claim for damages for non-performance of the export obligation, which complied with, well, it did not comply with national law. Under national law, it was for the buyer to clear the goods through export. Incoterms for the seller. And I dared to suggest then that Incoterms should prevail before national law. However, now the important question arises, and that is the nature of Incoterms. The very nature of Incoterms is they tell you what to do, but they do not tell you what happens if you don't do it. So the consequences of non-performance is quite another matter. And of course then I suggested that this was an impediment beyond control. So the buyer escaped liability and damages, and that is in Article 79 of the UN Convention. You see how these instruments work in conjunction, but never forget that Incoterms is not the whole contract. It's part of the contract, and primary purpose, apart from transfer of the risk of loss of or damage to the goods, these are rules telling you what to do, but no more.
I think that's a point worth emphasizing. A few years ago, I was sitting on a case as arbitrator. I was sole arbitrator, and one of the parties was adamant that Incoterms was about the transfer of title, which of course it is not. It is just the transfer of risk. It is so indicated in the Incoterms and in the wonderful commentary that Jan has wrote and that I would recommend to everyone without any reservation. It's good to remember the limits of Incoterm. Questions? Please.
Maybe returning back to our discussion about Lex Mercatoria and how they are applied in arbitration and in state courts. So we all are aware that it is perfectly possible to choose Lex Mercatoria or UNIDROIT principles as governing law if we simultaneously choose international commercial arbitration. But still it is problematic if the case goes to the state court. And my question is that while drafting the Rome I regulation on the law applicable to contractual obligations, the European Commission tried to include in Article 3 the indication that the parties could choose such a national instruments as governing law. But this attempt failed, and now from preamble to Rome I regulation, one could come to the conclusion that only incorporation by reference of such sources is possible. So my question to Professor Ramberg, do you think this attempt of European Commission was right, and why it failed, so the time hasn't come for such a situation that state courts are ready to apply such sources as governing law? That's the first question, and if it's possible, only the second, also the second question may be quite provocative question. I think nowadays it is a kind of fashion to draft different restatements of contract law. So we have UNIDROIT principles, we have Landau principles, we have draft common frame of reference, and a lot of other projects made by mainly academics. Don't you think that the more such bodies of a national law we have, the more problematic becomes the choice of Lex Mercatoria, because it is difficult to understand which a national body of law is going to be applicable. If we don't name it precisely, if we don't say that UNIDROIT principles should be applicable, instead of this we just write in our contract that Lex Mercatoria should be applicable, then we have a problem that there are 5, 6, 7 different bodies of such restatements, and so which of them should be applicable if there is a contradiction in particular issue? Thank you.
Well, very good questions, both of them. I will take them in order. Now, I did mention that Incoterms, if you ask me, do they represent Lex Mercatoria? My answer is yes and no. Some of the Incoterms would, I think, still be Lex Mercatoria. Others, in particular the brand new ones, cannot possibly be Lex Mercatoria because they are not yet known, widely known. They will be, perhaps, but they will take 10 years, 20 years, 30 years, I don't know. So anyway, again, refer to Incoterms. Question number 2 is very important. And I had to present, well, I've had on numerous occasions, something which was produced by a bunch of law professors. And it was an organization which was, well, a council which was introduced in Paris 2001, which is called the CISG Advisory Council. Now, that consisted, to begin with, by some 11 professors picked from different regions of this world. United States, we had Alan Farnsworth, for instance, quite well known. England, Sir Royston Gould, and you know, quite big names. And we had Sergei Lebedev from Russia, and so forth. And I happened to come into that group, I think primarily because of Incoterms, but anyway, in this distinguished group. But then I became the chairman of this group, and I had to explain, what are you actually doing? Well, we have provided now today up to 9 opinions how to interpret the convention. What authority do these opinions carry? Well, as a formal question, none whatsoever, except the names behind the opinion. And I say, you save transaction cost. You don't have to read all our books. You could read the opinion. You save time, don't you? We lose royalties, but never mind. So this is our common opinion, and there are no dissenting opinions in this group so far. My answer is, you must distinguish between law in form and law in fact. Law in form, no value. Law in fact, great value. Numerous references to the opinions have been made by courts of law, arbitral tribunals. Well, I would say that UNIDROIT principles and principles of European contract law, and even the draft common frame of reference that you referred to, they have, of course, bigger value than the value of this council. And the value is that they are actually applied by courts of law. They are not law in the formal sense, but they become law by the power of persuasion.
Thank you, Jan. We have to move on. Now let me ask you, would you like to have a break? You've heard so far 3 of the 6 speakers. We're doing well on time. I love the interaction that we're having. So would you like to have a break now, or shall we continue and have more time for Q&A afterwards? It's really your call. Continue? Everyone agrees? I think that Alexandra is concerned that if we were to allow you to leave the room, you might not come back, so it's better to keep the doors locked. With that, I would like to continue the trilogy of drafting the common rules for
Mr. Chairman.
trade finance.
May I just make one comment? There was a point raised about trademarks. And actually, it was although my presentation comes later on, I thought I'd just interject on that point. It's a very interesting one because it applies to standards, and standards and the role of intellectual property is very controversial at this point. However, if you considered not the rules at stake, but a trademark on certain technology, such as a fuel additive, which I obtained a patent on, if that formulation became a national standard, you would be highly outraged if the company that owned the patent decided to claim a royalty from everyone using it after it had been made a standard. And so in this way, when you participate or you offer up your technology to standard making, you must grant a license. Okay, and in this way, we're talking about a trademark, and it is not about the copyright in the content, because although there is one, a license would have had been granted to the standard body for royalty-free use. But the name is a little bit different. That can be licensed as well. It conveys the goodwill of the ICC organization, and of course we're always looking for new members, so that's perhaps why we've trademarked that name.
Thank you, David. Jim, I'd like to turn over the floor to you and the role of uniform rules, standards, and trade practices in the modern trade finance.
You got one there. Yeah, okay.
Oh, yeah.
This thing, I think.
Oh, that one. No. It's,
What'd you do with it? Who took that? Here it is. I don't know where it was, but before you do it, you want
You know, I'm going to have to borrow your mic. I can't move this. Thanks. I'm going to have to borrow your mic as well. Let's see if I can move this. Good. Well, the topic, or at least the title of what I'm going to speak about, is, at least to me, a little bit obscure. It's called The Role of Uniform Rules, Standards, and Trade Practice in Modern Trade. And the question I have is, what exactly are these things? In a sense, it seems to me they're not exactly the same. Standardization is something that is critical for modern trade, but it's somewhat arbitrary. What is Texas crude, for example? Well, what's a certain brand of vodka or of wine? There are reasons that companies would want, or that industries would want, or that governments would want standardization, and it certainly leads to efficiencies. But I would hardly call those uniform rules, because the point is you're going to buy and sell vodka of a certain brand, oil of a certain brand, gas of a certain brand, and so it's an identifier. On the other hand, trade practices, to me, is quite a different phenomenon. In a certain sense, it may be, for example, what entities do, but not necessarily, and I think that's not the sense in which one typically uses the term of trade practice. For example, and I'll draw from my field, it is a practice that some banks will entrust a letter of credit, a standby letter of credit, or a demand guarantee to their customer to effect delivery to their customer, the beneficiary of this undertaking. So that's done, and if a trade practice is what companies do, then that would be a trade practice. In my opinion, it's a bad practice, or at least not a wise practice, because it obscures the fundamental question of at what point is the entity which has issued the undertaking, typically a bank, obligated irrevocably with regard to its commitment. And because there is in the field of letters of credit nothing magic about the unique piece of paper in which the undertaking is contained, it's not like commercial paper where you merge the obligation with a piece of paper. Having delivered it, even to your customer, the bank is obligated. And whether or not the beneficiary has the piece of paper, it's still entitled, if it can do so, to make a complying presentation. So is this a trade practice? Well, in one sense, yes. It's something companies do. But in another sense, it is not, it seems to me, the kind of trade practice that really ought to be idealized. And then finally, the notion of uniform rules. Really, I think we have two things here. One, rules. Rules, it seems to me, are things that are articulated, although I suppose they could be more loosely articulated. And then there's the question of uniformity and what that amounts to. I'm going to avoid all of this and the confusion and the jurisprudential problems inherent in it. And I haven't even mentioned one of them, which is, do the parties agree to this? From my world, which is a common law world, the agreement of the parties to what is a customary practice is irrelevant. They can disagree with respect to it. In other words, they can say, we'll take ourselves out of that customary world, but the customary practice would apply inherently if it is indeed a customary practice, unless you chose to depart from it. So in any event, I have 4 points to make. I will make them very simply. We were going to divide this up, and so I put it into 2 presentations. Hopefully they're all in 1 point. My first point is simply that rules of practice, in the sense of articulated rules, are absolutely vital for trade finance. They serve an extremely important role. But what they are or how they work differs somewhat. Jan has just given us a magnificent overview of Incoterms. To me, this is what I would call definitional rulemaking. It's not really a rule in the sense that you enter into a system, but if you use this word, we will now tell you what this means, and that's extremely valuable. But only one, and I think a more elementary and primitive stage of the process of rulemaking. There's another stage, which I call, I guess this is the American in me, traffic rules. That is to say, it doesn't matter if it's this or that. Think of driving. The English think that the right side of the road to drive on is the left side. We think that the left side is the right side. No, I've got it backwards. Well, anyway, the right side's the right side. It's the English who think it the other way. Me, I never know what side to drive on. I just do what everyone else does. So, for example, Jan will remember when he was young, during World War I, that there was an enormous problem of what it meant when you agreed to have a bill of lading. Did it mean the goods were laden on board the vessel or simply received for shipment? Huge difference from everybody's point of view. And during World War I, there was such a backup of material going from the Western Hemisphere to Europe that whereas before there had been a demand and an assumption that if you called for a bill of lading, that unless you said otherwise, it would be that the goods were laden on board the named vessel. During World War I, buyers in Europe were so anxious to get, and it would be particularly governments, so anxious to get the goods, they'd take anything. So they would take a receive for shipment bill. Well, it doesn't really particularly matter whether it's an on-board bill or receive for shipment bill, as long as you're clear, and then the question is, what's the assumption? So I would say there's no, quote, practice. It's simply a traffic rule. Will the assumption be that if you call for a bill of lading and don't specify otherwise, you get an on-board bill, or will it be that you get a receive for shipment bill? And so rules can, in a sense, serve the function of providing a traffic rule for what is the default. Thirdly, these rules can state, and to a certain extent, Incoterms has ventured in that, at least implicitly, but explicitly as well, what are the obligations of the parties? For that to happen, and to be binding on the parties, they probably would have to consent to it or issue their undertaking subject to it. So I'll move into the world of collections. Under documentary collections, a bank that issues its collection letter subject to the URC has certain minimal obligations with respect to the documents that it receives. It can't turn them over, for example, to the entity on whom the draft is drawn without receiving payment or acceptance, depending on whether it's DP or DA, but has no obligation with respect to the documents otherwise. Then finally, there are what I would call integrated systems, and the rules of which Georges spoke, the Uniform Customs and Practice, the International Standby Practices, the URDG, I think are quintessential examples of integrated systems which include not only all of these elements, but go further and have a regime of sanctions, which are the sorts of things you would think are more typical of law. The classic example of that is what's known as the preclusion rule. If you fail to give timely and adequate notice of having refused documents which are presented to you, you are precluded from asserting that they're not in compliance with the terms and conditions of the undertaking. That is a draconian sanction. I can't imagine a legal system imposing that, because it doesn't matter whether you could cure them or not. But for the integrity of the undertaking and of the system, this is a rule which has been adopted. And so, in a sense, what practice rules are depends, but in my opinion, there's an absolute vitality to them. Well, I may not be able to go any further. Can you all make this thing move, or is it me? Or do I have to put a coin in it? Ah, there we go. And this is basically, I think, what I said. There's perhaps I should say, with regard to the UCP, the notion of letter of credit, the definition now includes, whether that was wise or not is a different question, the notion that if you're talking about a letter of credit, you're talking about an irrevocable undertaking. With the advent of electronic commerce, there was a serious question in the 80s. If I send my undertaking electronically and follow up with a mail copy, and if the two aren't identical, is the mail version the operative one or the electronic version? And there was an enormous switch in the rules in 1980 to make the electronic version the operative instrument, unless you said that it was not. Before that, it was the opposite. So this, I think, shows an illustration of the wisdom of UNCITRAL in saying, look, we're not going to get into the details of practice, because over time these things can change, and indeed they have. Well, the second point I have to make is that the existence of a rule doesn't necessarily mean that it is successful. George mentioned, I think, some very good points about what the criteria are for rules. Maybe I'm just going to point to one. They need to be neutral. When the UCP began, it created a rule that if you were talking about a letter of credit subject to the UCP, if it did not say that it was irrevocable, that it was then revocable. This, it seems to me, was a bad rule. It undermined the credibility of the instrument, the assumption that everyone made when they got a letter of credit and didn't know anything more was that it was irrevocable. And to realize that only the insiders realized that if you didn't say that it was irrevocable, that it could be revoked. Well, in fact, at least in the United States, The courts weren't happy about that, and so, as common law courts can do, often found their way around that one way or another, and were reluctant to enforce it. Happily, the rule shifted, and now it's inherently irrevocable. But enough of that. The third point I have to make is that trade practices don't work without infrastructure. Some of you are old enough to remember, maybe it's just Jan and I, at a certain point, a certain country in Africa, flush with oil dollars, decided to build itself essentially a new country. And one of the essential ingredients in modern life is cement. And so they ordered endless amounts of cement, except that they didn't have the port facilities to even get the cement into the country. And so you had lines of vessels incurring demurrage fees stacked up at the ports of this country because they couldn't even get the cement into the country. And the point is, well, it takes more than buying cement to build something. And so there are other elements besides practice rules which are essential. They include law, both positive law in the form of statutes and judicial interpretations of law. They include regulation, which it seems to me goes to safety and soundness. What's appropriate for law? Well, George mentioned fraud or abusive drawings. It really probably wouldn't be appropriate for rules of practice to address what constitutes an abusive drawing. On the other hand, it would be entirely appropriate for rules of practice to say this type of entity, in our opinion, is a protected person who, notwithstanding fraud on the part of the beneficiary, ought to be protected from the implications of that. For example, a nominated bank that acts pursuant to its nomination. The fact that you can issue, for example, a demand guarantee or a standby letter of credit doesn't necessarily mean that it is a safe and sound practice for you to do that. But you wouldn't expect rules to address that, but you would expect bank regulators to say, you must treat this like a loan. And if you don't, you run the risk of not being able to engage in the practice of banking. Another aspect of this process of infrastructure is standardization. SWIFT certainly assists in the letter of credit world, and there is an important role of forms. One of the things that George's group did in promulgating the revision of the URDG was to include standard forms. With respect to the international standby practices, after about a 6 or 7 year process, we have just released standard forms to be used in connection with the ISP. One example of what we've wrestled with was automatic extension clauses. It was expected at one point that a standby letter of credit would have a fixed expiry date. But an expiry date of 20 years is not safe and not sound. So if you are to provide that it expires on an annual basis, this is probably not going to meet the needs of the beneficiary. But if you provide that it will be up for consideration with the possibility that the issuer may say, we choose not to extend it, and then provide a time frame within which the beneficiary can draw or the applicant can seek it replaced, that is a viable alternative and actually quite an attractive one. But you can't address that by rules. You need forms that will give the options to the parties to deal with all the various contingencies that might arise. And then, of course, there's the element of institutionalization. The ICC does a very nice job of supporting and backing up its rules. And then finally, the fourth point I have to make is that the relationship between law, whatever that is, and practice, whatever that is really two-sided. In my opinion, law ought to defer to sound practice. But it also, I think, on the other side of it, has the role of encouraging sound practice and discouraging unsound practice. And how that's done, of course, is in a sense the trick. But George, that's all I have to say.
Thank you, Jim, for those great remarks. Questions for Professor Byrne? Let me add perhaps my personal view about something quite intellectually rewarding that did not suspect that we would get out of drafting rules for demand guarantees. Of course, we were hoping that they would become the standards, the world standards for businesses and banks all over the world, and I believe that we succeeded in doing that. But then I got a call from the World Bank after the adoption of the URDG saying that we're about to modernize secure transaction laws in 15 countries in Africa as part of the legal framework of the Organization for the Harmonization of Business Law in Africa, an organization called OHADA, O-H-A-D-A. And we chose the URDG as model framework for the chapter on demand guarantees. And that made my day. I thought that was really something that we did not expect and that we were rewarded with, and I'm particularly proud of that. So this is to tell you that sometimes you can obtain reward not only in reaching your objective, but in exceeding that objective, and this is wonderful. Questions for Professor Byrne? Well, if not, we're left with two distinguished speakers, and I have the very difficult task of deciding if we start with David or with David. I thought that maybe a proper approach is the drafting approach. The very last clause that you turn to when you draft your contract is the dispute resolution clause. So, David, if I can ask for your patience, then I will give the floor to Mr. Corris to add his point of view, his experience, and it is considerable in drafting uniform rules in international property. David?
Thank you, Mr. Chairman. Distinguished colleagues and ladies and gentlemen, well, this is the part of the presentation today which I consider to be the most exciting. Intellectual property is something that is in the newspaper every day. It's in the discussions at major events at the UN. Who hasn't heard about the discussions about climate control? We are in the age of the digital economy. And it's more than once it's said that intellectual property is the currency of the digital economy. So I think it's very appropriate that we talk about this. Now, we've been talking about aspects of legal transactions. And certainly there is an aspect of intellectual property where once you have created something, and through the rule of law and regulations, you then enter into agreements to transfer rights to use that intellectual property to third parties. I see alignment there. There's also alignment in the sense of rulemaking. Now, although I'm not going to speak a great deal about that aspect, I can say that April 24th, the IP Commission, which I represent, was in New Delhi, where we were engaged with various government ministers, academics, as well as interested parties in the creation of a national IP strategy. So if a nation wants to move forward with the way it handles its innovation, and I submit there is good cause to do that in this age of competition, there is nothing like having a plan. Yesterday I had the great pleasure of speaking at St. Petersburg University, where we're also beginning the discussion about a national IP strategy. So I think there's a lot to be said. There are 23 nations around the world that have IP strategies in place, and I'll be speaking last on my list of topics to cover. So where does that leave us? First off, I think I need the slide changer, if I may. I can begin just saying briefly that as General Counsel of Shell. I handle the global intellectual property. That's the creation of new technologies, protecting it, transferring it either directly to third parties through a license arrangement or engaging in contributions of the intellectual property in joint ventures, such as you might want to form to put in to engage in an onshore or offshore oil or natural gas venture. Okay, so what you see up here is my agenda. First, it's really a three-part presentation. The first part is a bit more about statistics, where we're making the global case for the role of intellectual property, and I will be covering that in my initial segment. The second part is really what constitutes the IP system, what constitutes IP systems of the world, what are its critical parts? Well, very simply, first, you must create a technology before we can engage in any form of contract where we transfer it. So what drives innovation? Second part is reliance on the rule of law. We talked about cross-border commerce, cross-border transactions. Well, certainly we are in a global economy, and if it's not sold digitally, your business planning is critical, and you need to be able to rely on the rule of law. But there's a more private aspect of the rule of law when you talk about innovation. That is the implied social contract between society and the creator of the technology, that the full value of that creative effort will be realized. It wasn't too long ago that I had a call on the weekend from a gentleman from the Ukraine who had created a new medical device. And he was quite excited about it. He was a private individual, and he was using his family's money in order to create the product, start a business, and as is true with many startup companies, he was nearly out of money. But he wanted to sell this product. He wanted to form a corporation. And so we began a series of discussions about what's necessary to form that. Certainly, the areas where he chose to obtain intellectual property and hopefully extract full value for that intellectual property depended upon whether there was he could rely on the rule of law of that country or group of countries. Last but certainly not least is once you have created the technology and you have the intellectual property that relates to it, you must then engage in commerce. Now, I have two simple case studies that I would like to show. That will happen in the second portion of my presentation. One is a simple license, and then one is a more complex multi-party arrangement. Quickly about the IP Commission. I'm the chair. This is a voluntary activity that I engage in aside from my day job. Headquarters is in Paris, and we have a number of national chapters in roughly 50 countries. Those national chapters are very important because my commission engages with the chairs to get updates on what is happening through their efforts in addressing critical intellectual property rulemaking, providing comments on rulemaking, and we take that back as part of our annual plan and look to address that. Okay, I have a series of 5 or 6 slides on statistics. Well, we've all heard about the change around the world in the efforts by some nations to increase their intellectual property. This is a slide, and just for those of you that can't read the English, it says demand for patents and trademarks has intensified to unprecedented levels. So this has 2 graphs. The colors on the graphs are for 6 countries: Japan, European Union, China, India, the Republic of Korea, and the US. Now, the point of this slide is really the left is measures patents, the right measures trademarks. But what you can say is that since 1980, there are roughly about 800,000 patents. In 2009, there's 1.8 million. The role of trademarks has moved similarly, increasing year over year, but certainly much more in the last few years as the role of intellectual property becomes more predominant, as the long-sought solutions for many of the world's problems are based on technology, or at least the solutions are being looked at in view of technology. And although it's not up there, we have a right called a design right, which has been steadily increasing over the last 16 years and numbers about 640,000. And why is this all important? Well, we need to look at the impact of those nations with strong IP systems and what their impact was in terms of GDP, employment, and international trade. Should be no surprise that we're seeing a shift of patent filing from the west to the east. I think that the rate is remarkable. And so China, I would say, has outstripped many nations. It began with roughly about 1.8% of the world's patents in 1995. Now represents 17%. Likewise, Korea moved from 7.5% to 9%. You can see the thin slice next to the green color. That says the Russian Federation. Russia has been pretty consistent, but I would submit that with a nation with the resources that Russia has, with the talent for creating new technology that Russia has, there is really no excuse for a patent filing level at 2%. I think this nation has the ability to leapfrog that to become much more of a world leader in the generation of intellectual property rights. All the tools are there. The next slide I have is really focusing on trademarks. Now, why are trademarks important? Okay. Yeah, trademarks. Well, if you're talking about the creation of patents, more than likely you're talking about capital investment. For developing economies, investment in trademarks or copyrights is certainly a lot easier. It does not require capital-intensive investments, and so it's a great tool for many nations. And I think that you can see in the slide to come that in terms of increase in GDP, that's something that we see in moderate economies. There was one slide I skipped over here, and that deals with something called PCT. PCT is what you call a world patent. It's has over 60 member countries, and essentially when you apply for a PCT patent application, it allows you to designate which member countries you would like your patent ultimately to issue in, and it is by far the type of patent filing done by large corporations because it allows for longer range planning, and within that assessment of risks around the world, including reliance on the rule of law and other tax considerations as well. Okay, I'd like to, in this slide, it really is talking about the GDP share by income group, and the relevant portion is, if you look on the middle columns, you see the term patent application, and the column starting for, it says 2009. You have 72.8% of the world's patent applications being filed by high-income countries, and that's with GDPs around, I think, the top 56, 57%. The point of this slide is to show that in the next column, which says trademark applications, you actually see the leaders in moderate income countries as far as GDP goes to be the highest level of trademark filers. Okay, only two more statistics. This really talks about international royalty and licensing payments. As of 1970, we were looking at royalty payments and licensing receipts from intellectual property around the world, about 2.5 billion. In 1990, it moved to 27 billion, and in 2009, we're looking at over 180 billion. So a fair bit of business is done solely through the licensing of intellectual property. And it's had a, okay, that was working nicely. Could we change the next slide? Oh, there we go. Okay. This is a concrete example. The country of Jordan, when it entered into the WTO, began revising its intellectual property system to create a stronger IP set of rules and regulations and practices. And as a result, we saw that a gain in GDP of roughly 21%. A lot of this came through the use of copyrights. Okay, so we see that correlates with roughly a move of 1.7 billion in 95 to 2.1 billion in 2005. This is a recent study from the Commerce Department in the United States. I thought I would point some of this out. Now, what the study did is it took a look at 75 out of 313 intellectual property intensive industries, and it attributes roughly 40 million jobs and a contribution of over $5 trillion, or 34.8% of U.S. GDP, based on intellectual property from these intellectual property intensive industries. We see merchandise exports from these IP intensive industries at around $775 billion in 2010, reflecting roughly 61% of U.S. exports. The copyright industry grew by 46% between 1990 and 2011, and that represents roughly 16.5% of all jobs in that area. So these are the statistics that I wanted to make quickly in the first part of my presentation to support the case that intellectual property matters. When I'm up next, I'll be talking about how large corporations create technology and use it in international transactions. Thank you.
David, why don't you keep the floor and go directly to the next part of your presentation?
Okay.
It's extended so that we can keep time.
My pleasure.
Questions and for David as well.
Okay. Well, how many in this room, if I may ask a personal question, have children? Have children? Do you have children? Okay. Well, then this slide, les enfants. Okay. If this triangle, if you've read a number of books about childhood development, should not be unfamiliar. Because corporations are very much like children in many ways, in the sense that they evolve, and particularly with respect to intellectual property. And this is a very useful concept for those of you that are either engaged in venture capital work or private equity, because you have to realize where a company is before you can assess it. So, for example, to help everyone, on the bottom you see a term reactive. Next up is defensive. Next up is integrated, partnering, and then leveraging value. Now, what might this is from an IP perspective, what might a corporation be in a reactive stage? You might expect to find a chairman of a university who desires to form a spin-off company, and bringing in a number of colleagues has as its goals prove some technical milestones, create a certain measure of intellectual property, and then get second round funding in order to move forward. The next level up, you have a different chemistry inside the organization because you actually have to make a product that brings on a whole set of knowledge requirements, ability to engage in national and international contracts. There has to be some knowledge about intellectual property because it's a necessary evil at this stage. It's more, business management is more familiar in terms of liabilities associated with intellectual property. You can be sued. Business plans that are sued on the basis of intellectual property can have injunctions assessed against them, shutting down their business. So clever business managers need to consider that and work out contingencies. But still, it's not quite understood, intellectual property that is, and it is a necessary cost. So as you move up towards the top of this triangle, the typical business school demonstration of Venn diagrams, 3 linked circles, one representing a business plan, another representing a technology plan, and a third representing intellectual property, must not only must be linked, but as you move towards the top, it must almost becomes concentric. So that presents some very interesting challenges for business planners, because if indeed those circles are concentric, then you have a business plan being created with the idea of what technology is critical in order to achieve those business goals, and what intellectual property is necessary in order to affect the kinds of transactions necessary to achieve your goals. Leveraging value is the top of this stage, top of this pyramid, and I'd like to talk to you a little bit about what goes on at that stage. Okay, this is not an easy thing to see, and I'll try to help our colleagues in the back. I see our translator with a set of opera glasses, but this is a typical speedometer that you might see in an automobile. But around the dial, you see on the far left the term R&D contract. On the far right, you see something called open innovation. Straight up on the top, you see a vendor-supplier relationship. Immediately to the right of that, government-funded, sponsored R&D, so you can create new technology by a host of different legal tools. Okay? Each is necessary to create its own special environment to help inventors create that much sought after technology. And so at the top of the development pyramid, you will see an organization that is very skilled at choosing for each given technologies what flavor, if you will, of process they engage in order to create technology. The lawyers that are involved in supporting that business likewise have to have an understanding of what the domestic and international requirements are for setting up these arrangements. This includes formation of a minority share joint venture, a majority share joint venture. Not mentioned is the formation of holding companies in tax favorable jurisdictions to house intellectual property, and the licensing then of that intellectual property on a global basis. Having an understanding of what the legal requirements are to engage in setting these licenses, having an understanding of the tax consequences is a very important part of this activity. Okay, we begin now to one of 2 case studies. This is, if you're going to talk about intellectual property and you're going to try and reach people, what better to talk about than milk? Okay, it's something that translates. If I found bread, I would have used bread. But this is from the Netherlands, and this is the Van der Lele Dairy and Cattle Farm. Mr. Van Lele was a dairy farmer, is a dairy farmer, and in 1948 obtained his first patent on a machine for milking cows. Now, you would not expect someone engaged in this kind of activity to be an entrepreneur, to be forming a business. But what this slide represents is the potential for, within any nation, to use intellectual property to create a business that can flourish within its own national boundaries, as well as, although it doesn't say it here, engage in international transactions as well. So what Mr. Van Lele did was take 6% of his income from the sale of milk, and he put it into research and development. He created a number of patents, and at this point it shows that in addition to having, in 2007, 985 employees, 50 researchers, but over 2,300 patents. So what does he do with this? Well, in addition to forming partnerships to create new technology, having research done in-house, he also extracts licensing revenue through means of a contract with third parties that are acceptable, and the terms of the contract, what we call a simple license. And the most important part of a license, I would submit, are the granting of rights to the intellectual property to the recipient. So the grant section is most critical, and it simply would be the granting of either a non-exclusive or an exclusive right to use the patent. In this case, it would be the granting of a non-exclusive right to use the terms, the claimed terms of his patent portfolio, which, for those of you not familiar with patents, what you need to think of them as are largely deeds to a piece of land. So a deed to a piece of land is a legal document that sets out the boundaries of a piece of land. Patent does the same thing with respect to an invention. It sets out the boundaries. Now you can lease like you can lease land or sell land. You can do the same thing with a patent. And what you are engaging in selling is what's found within the four corners of the claims of the patent. So in addition to licensing patents, Mr. Van Lele also has trademarks. This is his product, and he engaged in licensing the brand. Now, patents have a life of 20 years, generally, but trademarks go on for forever as long as they're being used, and the maintenance fees are paid on the trademark rights. And so another example I have is I engaged with a gentleman called Dr. Maherkar. Dr. Maherkar had a world-class dialysis catheter, and that's a device for insertion into the bloodstream that allows the cleansing of blood. So this is the means of essentially what gets inserted into the vein. Now this dialysis catheter was found to be virtually the best there is by a number of different hospitals that made that decision by the marketplace by buying that product. Patents long expired, but because he had put his name on that particular catheter, it lives on well beyond the time period now. There are very few hospitals in the world that are not asking for the Maherkar catheter. So through the combination of both, Mr. Van Lele has his name on this product, and it continues to collect royalty income to him. Now, the next slide is the second of the two case studies. This is very relevant for developing economies, and particularly with respect to the creation of drugs that are necessary for afflictions or diseases where there is not a lot of attention. One of them is malaria. So this particular model demonstrates how a corporation will consider how to make an investment, secure its mandatory return on investment, but in addition have the capability of generating a product that is not for loss, but not for profit. Okay? So in this situation, you had a number of parties. You had the Gates Foundation, which essentially provided the funding without any financial requirements tied to it. You had the University of Berkeley, who was charged with creating the technology. You had a startup company that came from University of Berkeley that was charged with developing the applied technology. That would be how to actually make the particular product. And then you had something called a practicing development partner, which is essentially the project manager of the operation, each getting rights from the technology created by the University of Berkeley. And what's interesting in this is that you had, in those rights, you had a requirement for the commercial entity that in the event they did not sell a sufficient quantity of the malaria, this is a malaria vaccine, they did not sell a sufficient quantity of the malaria vaccine, there would be a grant back of those rights back to the licensor. So it's a condition that when combined with the right to sell, to use the intellectual property for commercial purposes on other vaccines, allow the manufacturer to get its return on investment, but in addition, create a market and sell products on a non-profit basis. The very last point of my presentation deals with the rulemaking, and what I've put here is essentially a summary of what I found to be common terms found in the national IP strategies of the 23 nations that are engaged in, that have national IP strategies. And it begins with the statement that national IP strategy should be aligned with a nation's IP vision, which promotes innovation, creativity, and global competitiveness. And this then ends also on point 7 with the idea that a national IP strategy should provide the means for national governance and coordination of the various ministers that are engaged in authorizing these rules. So this is something that I see as the shortest way to move forward for a nation in creating a modern-day intellectual property system. And I have to, just as final word, every nation is is evolving their IP system, both by regulations, addressing the courts. And I notice that the Russian Federation has done a great job in its codification of its rules regarding the courts. So good work there, but there is much more work that needs to be done. I noticed that likewise the United States has engaged in significant changes in its Invent for America Act. They do not have a national IP strategy, and David Kapos, the Undersecretary, has this on his agenda to put together. China has it, Japan has it, as well as 23 other nations. It comes with high recommendations, and I believe it's going to happen here, and I believe the ICC will play a significant role in reviewing that document. Thank you very much.
Thank you so much, David, for those remarks. I will use the chair's prerogative and ask that questions to Mr. Corris be withheld until the end of this workshop, because at the passing of time, he will be available for a short period of time because, as he said, he is due to the university to have another session with the students. And by the way, I am hugely admirative of this wonderful work that you're doing with the university. As a reward for those of you who were valiant enough to stay until the end of the roundtable, now we're moving to what is arguably the most important presentation because, ladies and gentlemen, everything we write in our contract depends on its enforceability on the desire of the judge. And where that judge is an arbitrator, well, that arbitrator will decide whether the reference to Incoterms, to ISP, to URDG stand the test of the interpretation of contract. And this, I believe, is part of what David will be telling us about.
Thank you. Well, usually the audience, it is massive audience, so I can say whatever I want, in effect. Yesterday, the chairman of the Supreme Court, Supreme Arbitrage Court, made quite an attack on different legal systems, saying that there is improper competition between different legal systems. And, well, he didn't name any legal systems, but we know which legal system he meant. So our Minister of Justice, I mean English, or UK Minister of Justice, also known as Lord Chancellor, also known as Speaker, also known as Secretary for the State, he made the response. And that response was not particularly impressive. It was defensive. It was saying, we are not forcing anyone to come to England. Everyone comes of their own will and accord. And English law is the best anyway. So that was the approach. So I have a different response to Judge Ivanov. And my response is today in front of this massive audience, which is English law is not the best. And when you come to Lex Mercatoria, it is by far, I mean, the approach of English lawyers is by far not the best. Well, I had a look at Wikipedia, and it was very interesting. In effect, I think it reflects the understanding of Lex Mercatoria by English lawyers, because it says Lex Mercatoria is the body of commercial law used by merchants throughout Europe during the medieval times. That is the definition. So medieval times, that's what English lawyers think of Mercatoria. And obviously many would not even regard it as a binding sort of set of rules. But anyway, there is such a thing, and it is a hybrid, and the way arbitrators view it differs from country to country. As I've mentioned, the English lawyers would probably view it slightly differently. The English lawyers would be puzzled by what the parties have actually agreed. All these instruments that were mentioned today, the ICC or UNIDROIT or United Nations instruments, most of them would not exist in vacuum, English lawyers would say. And even let's say the demand guarantees document, there is a provision in the ICC document that actually specifies what law would apply to the actual guarantee. So for an English lawyer to say that there is a dispute, which is where the governing law is some kind of not law but set of rules or customs, is very difficult to understand. And English lawyers, well, with some exceptions, obviously, Sir Roy Good will disagree with me, or there are some others, but overall view would be that there is no such thing. You will always need to have national system of law. And obviously English law is the best. That's what the English lawyers would say. But when it comes to international trade, well, first of all, we didn't adopt the Sale of Goods Convention. So that is a starting point why English law is not the best. Secondly, I haven't had a single arbitration in England where Lex Mercatoria was used by the arbitrators as such, i.e. where expressly they said that they would apply Lex Mercatoria to determine the obligations of the parties. unlike the ICC practice, unlike the ICAC practice, LCIA practice, I don't think has any cases where express provision would be stated in the award in relation to the applicable law not being a national law of any particular state. So the way it evolved in England, well, in effect 3 stages, and it's not that interesting, the history, but the mere fact is that from approximately 18th century, it is considered to be part of law. Although what is it? Lex mercatoria. So part of law, merchant law. And to look at the modern days, I will skip all these slides for a number of reasons, because there have been very, very detailed presentations in relation to what is understood by Lex mercatoria. I'll just use my views, which I think represent views of many English lawyers, and those involved in arbitration, how Lex mercatoria is or is not applied in international arbitration. Again, Vladimir provided some statistics, well, he didn't provide statistics, although he has some statistics in relation to how many cases or how many awards are out there which referred to Lex mercatoria principles in one shape or another as governing law or governing principles of obligations between the parties. And again, it is very interesting to see that notwithstanding that continental lawyers would normally say that it is better to have to have the civil system is better because there is a written law. There is something that you can find somewhere, unlike common law system which is based on precedent and therefore it is not that predictable. Common law lawyers say exactly the opposite. We would say that English law is predictable because you have this set of a body of precedent where you can predict exactly what the outcome of a dispute would be. But when it comes to trade usages and all what people here in this room call Lex mercatoria, it's quite the opposite in my view. It is the common law lawyers who are more difficult and who want everything to be on paper, whereas civil systems lawyers, they are happy to deal with principles which may or may not be either on paper or at least in one paper. As George has said from the very beginning, what is Lex mercatoria? Where do you find a book on it? Well, you can't find a book on it, and most arbitrators in England would say there is no such thing. They would say, well, what we understand is national law of any given state. So when I sit as an arbitrator, most arbitrators in England would say, we want to determine what are the applicable rules, either by the choice of the parties, or if the parties haven't chosen, we will choose it for them, either applying conflict of laws rules or without, depending on our obligations arising out of the seat of arbitration, etc., or the rules. But we would still go into national law. And this is very different from the, well, some ICC cases outside of England, and also, as I understand it, ICAC practice as well, where it is more common to have Lex mercatoria applied in arbitrations. So I would say that in order not to, to leave more time for questions, I would just say that this body of rules, Lex mercatoria, for arbitrators would probably represent the written body of rules, i.e. various instruments mentioned today. All these customs, well, I mean unwritten customs, trade customs, etc., very difficult to determine what is the custom from the arbitrator's point of view. Experts, well, most of you gentlemen act as experts in international arbitration, I suspect. Well, I would say that many experts would say opposite things in front of the tribunal, and the problem the tribunal would have is to believe one or the other. And sometimes, well, maybe not on legal issues like this, but especially on oil quality, I find it absolutely useless to have experts in front of me, or transportation of oil, or some other interesting points. But in a nutshell, the arbitrators would prefer, if to use any principles, to have them on paper. And therefore, we come back to the ICC or UNCITRAL or UNIDROIT written instruments, in whatever form or shape they are. Some of them become law, as we already discussed it. Some of them never become law, but they're still widely used. One exception to that extent is Incoterms. I think it is difficult to say what exactly Incoterms is. Well, obviously, distinguished professor whose life is almost sort of, well, dedicated to Incoterms would say that probably it is Lex Mercatoria. But to me, and I suspect to many other arbitrators, it is way higher than what we would consider Lex Mercatoria. Incoterms is probably a standalone document. The reason is that it sets out very clearly obligations of the seller and of the buyer, and it is so widely used that for some reason it is, well, more accepted by arbitrators, let's put it this way. The demand guarantees is another example of sort of next closest, in my view, which arbitrators would very happily use in their award. But again, different approach. And when I said that in my experience, well, I've had my share of cases, not that many, but not that little, probably in excess of 200 different arbitrations under different rules, either as counsel or as an arbitrator. And I've never had a single case where applicable law was replaced by some kind of Lex Mercatoria. Not a single case. I had one interesting case which shows difference in approaches of different, well, arbitrators coming from different legal systems. And that is a case which was heard in Geneva under the ICC rules. And we had a Swiss chairman, and it was a bank guarantee case. I was acting for one Russian bank against a very large French bank. And we alleged fraud on behalf of the French bank. We said that the French bank committed fraud. Then the question was, under which law we need to prove fraud, because there is different burden, different standard of proving fraud under different systems of law. So one of the questions was what is the applicable law to the contract, to the actual guarantee? My submissions were that in accordance with the, well, there was an express provision to the ICC publication. The ICC publication has an express provision in itself that if the parties haven't specified the applicable law, then it is the country of the issuer. So in my submission, there was an express choice of the law by the parties, which in that effect would, well, in that particular case would be Russian law. But the French bank argued otherwise. They said, no, it's definitely not Russian law. It doesn't matter which law it is, but we will argue it under French law. And it had nothing to do with France. The delivery was to Austria. And it was, it was completely, it just happened to be a French bank, nothing else. So an English arbitrator would normally determine the applicable law at the very beginning of the case as a starting point, so that the parties at least know under which law they're going to argue their cases. And what happened in this case? A Swiss, very well-known arbitrator said at the preliminary hearing, no, it doesn't matter. You argue your cases the way you want, and we'll see and determine what the applicable law, if any, at the award, well, in our final award on the merits, which is an approach that English lawyers would just simply not understand. Because we want law, we want some hard law, preferably English, which is the best, we say. And we argued our case under Russian law with an alternative argument under French law. We said that even if Russian law were not to be applied, then it would be Austrian law. Even if you, for some silly reason, thought that it was French law. And we argued, in effect, under three systems of law. The French bank argued under French law. And the award didn't really specify which law the arbitrators applied. I didn't care, and I didn't appeal the award because I won. That's why I didn't go into it. But it is probably the only example in my whole career where there was no actual national system of law applied as such. Otherwise, all those cases, I think the statistics, they show that the parties do use lex mercatoria, but not in the classic sense as many people would understand what lex mercatoria is. They would either refer to UNIDROIT principles, in which way you have clear obligations of the parties set out on paper somewhere. They would refer to some other document where there is clear express provisions on obligations of one party and another. So that's the approach that at least, well, we see in England. And probably it means that at least for the trade contracts, for commodity contracts, contrary to Judge Ivanov's views, English law is not the best. Thank you.
Thank you very much, David, for those wonderful remarks. I was expecting nothing less of you. Now, at this stage and seeing the time, I was about to move into my closing remarks because we all know what happened to Cinderella when she exceeded the cutoff time. Her carriage transformed into a pumpkin, and I don't want any of us to risk transforming into a pumpkin. But I'm delighted to see that Mr. Muranov has joined us. And we have to find an equilibrium, Mr. Muranov, between the passing of time, the fact that we're already 10 minutes late, and the fact that we're delighted to have you here. So how about this deal? Why don't you restrict your remarks to 5 minutes, if I may ask you? Yes. And I know that the most interesting part will be left out, which is an incentive for all of us to come and see you after this roundtable and ask you for those remarks that you left outside. Would you accept this deal? Thank you. Would you like to join us and have your remarks delivered?
Я хотел коротко рассказать об
I'd like to speak very briefly about a special set of norms, WTO norms, the ones which actually make the foundation for the modern trade relations and interactions. We are used to the fact that the trade relations are being regulated by the private law. First of all, at the national level, and also it is regulated by the international treaties, and those sets of WTO rules are related to the relations between the private objects. So let me start with the list of the primary documents. 8 of them you can see on the first page, and there will be more on the second slide, and this is just a tiny share of the documents used by WTO, and there are bylaws issued by different committees, subcommittees, and so there's some case laws, awards, to say nothing about hundreds of documents issued by different ad hoc groups. And they all should be taken in consideration just in order to know what the WTO law is. So these are the principles of WTO rules. There are 11 such principles, or there might be much more of them, and if we compare those principles to those which are used in regulating the private relations between the stakeholders will see that they are coinciding. So, literally speaking, we can say that WTO rule is, or law is, an attempt to actually somehow translate the relations between the private objects to the intergovernmental relations. So, first of all, the liberalization of the trade, a principle similar to what is being used in the Russian law, cooperation of the bodies. And there is a joke that one of the main agreements within WTO, GAAP, ATT, is translated not the way it is, but this is the general agreement to talk and talk, not the general agreement of trade and tariffs. So the principle of most privileged nation, we all know that, the ones involved in the international trade, the principle of national mode or regime, the principle of banning the trade barriers, and also the accessibility and affordability of the remedies, one of the cornerstones principles, and there is also a special body to resolve the disputes, the safeguarding of the interests of international and foreign bodies. Now, there are several theories of the WTO law, and this is a kind of a philosophy. We all know about the economic foundations of the WTO, mutual interest and exchange of different concessions. Kant's ideas of the liberal world, we know that the trading countries certainly can stage a war between each other, but they are not inclined to do that. And at the international level, there is also a doctrine of international states, and we are discussing the legal grounds and legal foundations for the WTO. Actually, WTO was established no more than 20 years ago, and therefore there are two main theories: the theory of a contract, international contract, and a theory of constitution. There is a blend, a mixture of these theories, which, in my opinion, comply more with the reality. So the main essence of the WTO law is, if we, for instance, compare that to the first article of the Civil Code, which bans different restrictions to the trade in services and in products in the Russian Federation. And we may thus understand that the world can be regarded as a set of regions which may restrict the trade. So every nation imposes such restrictions itself, and that's why WTO pursues an objective to eliminate such barriers, such restrictions. That's why critics sometimes compare the activity of WTO with an organization which attempts to make a flat landscape, in contrast to the very diversified landscape we see in the world right now. But if we compare the situation within Russia, we'll understand that the imposition of the restrictions within the country is very detrimental to the development of the trade. Then we'll see that WTO pursues very favorable objectives, so it acts for the sake of the civilization itself. That's why WTO may be called, may be dubbed an experiment aimed at establishing one single international market. It is being implemented not by means of trying to regulate the rules and obligations of the trading stakeholders or trading countries. So its main objective is to regulate the activity of the states, of the sovereign states, and they should be bound by the rules which are regular for the trade usage. And so the main idea is of self-restriction, meaning that the state restricts and limits its own sovereignty, because the states commit themselves not to impose any barriers, not to impose any unfair tariffs and taxes. And so it means that in Russia, actually, the authorities do not understand, in my opinion, what it is, the lack of restrictions. And WTO system is the system of checks and balances. And WTO system doesn't impose any political restrictions, but actually it dilutes the national boundaries, because the political boundaries remain the same, remain intact, but the economic boundaries are diluted, they disappear. Because just unified economic regions are being formed. Now we have cultural boundaries, we have economic boundaries and political boundaries, so the main objective of WTO law is to destroy those boundaries. And this results in the following conclusion, that WTO law is, in my opinion, something brand new phenomenon in the history of civilization, brand new for the majority of the population, and probably not so new for the businessmen. And this really proves that globalization is a fact. The states have to act in the global sense. They cannot act just within their national boundaries. And for lawyers, it is very important that the WTO law is an instrument to fight the economic nationalism by means of restricting the national sovereignties and setting common rules for the states, for the countries, for the nations, which have to provide for the freedom of trade.
There's another interesting moment that I've got to mention. We all know that businesses on the international level require predictability. They need rules which are known in advance to them. We know that this process of creating uniform rules is called unification. And how can we assure unification of such rules? First and foremost, it's done by developing various international treaties between various nations and governments. And then the second way is just to have business rules and trade usages. And these processes speed up the creation and the development of international treaties in order to liberalize the trade in commodities and goods. But the traders are provided the maximum of freedom, and so freedom is the ideology of WTO rules, law. And so the traders are free to develop their new customs and the rules of the game. And here ICC maybe should provide assistance to the traders in developing such uniform rules. Maybe we're not talking about uniform rules in an international treaty, but we've got to pull down various economic barriers that affect international traders. And so WTO laws or rules act as a vehicle of collectivization, as we call it. Those people who come from Russia, they know this term. And so this is a vehicle for making nations and states to be mutually dependent on one another, maybe just to avoid local wars or global wars in the future, so that all the nations should be involved in the trade turnover. And thanks to the WTO law, we see a very complex mechanism for implementation. It's full of technical details, but in order, when we talk about international commercial law, we've got to study all the documents, all the tables and charts. These are not just declarative documents, because WTO rules aim at standardizing all the obligations, first and foremost obligations of the state. And so it incorporates various tables which specify all the liabilities and obligations of the nations, and they are mutually applicable rules and obligations, and so these rules and norms must be incorporated into the respective national law systems. And finally, WO law is a total and global law. This is a law about the trade relations and the freedom of trade relations, and that's why it applies to absolutely all the spheres of trade relations, and it applies to the supply and delivery of goods, customs clearance, the employment and the environmental issues, and etc. And so I believe that WTO has proved that its legal mechanism is quite viable, and so this instrument in my hand is just the results of the implementation of WTO mechanisms. And Russia is now a part of the WTO. It was a very difficult process, but we hope that right now we will also join the development of uniform rules. And as one of the WTO's representatives said, that once you have acceded to the WTO, your life becomes easier. Thank you very much.
Branov, and again, my apologies for having to shorten your talk, and obviously you're available for questions if anyone would like to. It's time now to move to the closing remarks and to bring to an end what I thought was really a very rich and a world-class forum on the legal framework in international trade. I think we were very fortunate to have such a distinguished panel. As you have seen, Mr. Koris, Mr. Goldberg, Professor Byrne, Professor Ramberg, Mr. Kalevei are all world experts in their area, and they have really went beyond what was expected to share with you their passion and their expertise, and for that, many, many thanks, gentlemen. I hope that you agree, ladies and gentlemen, that the panel was able to demonstrate the importance of having a common legal framework, harmonized rules, common rules to support international trade. And it is important to have that legal framework now. A friend of mine who sits on the board of the IMF likes to tell the story of when he went with an IMF delegation to Peru and discussed with the Peruvian finance ministry how to have the local economy built on a sounder basis. And at the end of the discussion, they spoke with the finance minister and they told him, now that we have agreed on the package of restructuring, when can you implement it? And the minister said, mañana. Mañana means tomorrow. And they said, okay. And then they went to their next stop. And their next stop was Greece. And they had the same discussion. And at the end of the discussion with the Greek Minister of Economy, they asked him, when can you implement this package of restructuring of your economy? And the answer was, avril. And the head of IMF turned to the translator and said, what does that mean? And she told him, well, basically, it is the same as mañana, but not the same sense of urgency. I think that it is urgent that we offer trade, international trade, a common legal framework. This would allow men and women all over the world to level playing field. That was what we endeavored to bring to you, and I would like to close by thanking very much my colleague panelists, the interpreters, and I apologize for having exceeded the time, and thank you for a wonderful interpretation, the conference staff, the two ladies who have brought us the mics, and you, ladies and gentlemen, for your patience and for staying with us. Thank you so much.